Subcommittee on the Constitution, Civil Rights, and Civil Liberties will come to order. We apologize for coming to order late, but the votes on the floor necessitated that. We'll begin by, I recognize myself for a 5-minute opening statement. Today's hearing is the beginning of a process through which this subcommittee will revisit the statutory framework Congress established in the 1986 Electronic Communication Privacy Act, ECPA, in light of the enormous technological advances which have taken place in electronic communications over the last 24 years. Because of the complexity of this subject, both legal and technological, this hearing will probably be the first of several we will hold as we consider what, if any, reforms should be made to the Act so that it might function more effectively in the future. ECPA was passed in 1986, well before we commonly use the Internet for email, much less for cloud computing and remote storage, at a time when cell phones were rare, often the size of small kitchen appliances, and included no tracking technologies capable of mapping our every movement. Communications technology now evolves at an exponential pace. So in 1986, ECPA fixed the statutory standards law enforcement would have to meet to access private communications data in a technological environment as far removed from our own as that of 1986 was from the day Alexander Graham Bell said, "Mr. Watson, come here, I need you," in the first telephone call 110 years earlier. The lightning pace of innovation in communications technology brings with it enormous improvements in the quality of life for our citizens that in many ways mark the age we live in as a new epoch, which might be called the Internet age. But it must be said, particularly by the Committee on the Judiciary, that these advances also provide criminals with new platforms for unlawful activity. Moreover, it must also be said here on the Subcommittee on the Constitution that these robust new communications technologies bring with them new opportunities for law enforcement agencies charged to protect us from such criminals to intervene in our private lives. Thus, we must consider whether ECPA still strikes the right balance between the interests and needs of law enforcement and the privacy interests of the American people. This is only the beginning of a dialogue that must go on to include the input of, among others, law enforcement at the federal, state, and local level, private industry stakeholders across the complex network of networks that is modern communications, and academic experts on technology, privacy, and Fourth Amendment issues. But today, all of the members of this subcommittee can begin this inquiry through a dialogue that raises these issues with this distinguished panel of witnesses. Today, we can begin the work of making ECPA work for our time and for all concerned. This is an enormous responsibility, and this subcommittee needs everyone's help to get it right. As such, all of us sit on this panel, at least in part, as students today. I thank you in advance for what you will teach us. As for myself, some of the questions I propose to the class are: how have changes in the Internet made it difficult for private industry to determine its obligations under Title II of ECPA, the Stored Communications Act? How do current advances in location technology test traditional standards of the ECPA of 1986? More generally, in what ways have these and other technologies potentially subverted one of the original and central goals of ECPA, which was to preserve, quote, a fair balance between the privacy expectations of citizens and the legitimate needs of law enforcement, close quote. If we are out of balance, what concepts should guide reform? I know my distinguished colleagues will have other questions. Finally, I'd like to observe that we are aware that privacy advocates and members of industry have worked together in an impressive common effort to derive and propose some common principles that should guide our inquiry on ECPA reform. I look forward to hearing them articulated by our witnesses here in person. It is my hope that we on this subcommittee can emulate your example and come together in a bipartisan spirit as we forge ECPA reform legislation that will put needed reforms in place, hopefully this year. I welcome our witnesses, and I look forward to your testimony. With that, I yield back, and I will now recognize for an opening statement the distinguished ranking member of the subcommittee.
Thank you very much, Mr. Chairman. The purpose of today's hearing is to examine the need to update the Electronic Communications Privacy Act of 1986. Today's hearing is the result of calls by a coalition called the Digital Due Process to examine how far apart technology and the law may have become and to see if reforms are necessary to keep the law current with constantly evolving technology. The genesis of ECPA in 1986 was a needed response to the emergence and rapid development of wireless communication services and electronic communications in the digital era. At that time, email, cordless phones, and pagers were, by today's standards, in their infancy. And as these devices have become smaller, cheaper, and more sophisticated, we have embraced them more and more in our everyday lives. The evolution of the digital age has given us devices and capabilities that have created conveniences for society and efficiencies for commerce. But they have also created convenience and efficiency for criminals, as well as innovative new ways to commit crimes. Fortunately, new ways to detect and investigate crimes and criminals have also evolved. At the intersection of all these developments and capabilities are the privacy rights of the public, the economic interest in expanding commerce, the public policy of encouraging the development of even better technologies, and the legitimate investigative needs of law enforcement professionals. While some of the issues we will hear about today have been heard before, this new initiative by the Digital Due Process Coalition was officially launched on March 30th of this year. There has been neither sufficient time to examine the concepts that are being advanced in any meaningful way, nor has there been time to hear from other stakeholders, including relevant members of the law enforcement community. While the Digital Due Process Coalition makes note that some of the principles have been previously embraced by the House Judiciary Committee in 2000, it should be noted that just last year, the full committee voted down enhancing the requirements for obtaining authority to utilize a pen register and for obtaining authority to utilize a trap and trace device. In fact, enhancing the standard for a pen register and a trap and trace device drew strong opposition from the National District Attorneys Association, the National Sheriff's Association, the Fraternal Order of Police, and the International Association of Chiefs of Police, all of whom agreed that the proposed changes to criminal pen register and trap and trace devices would unduly burden state and local law enforcement agencies that regularly use these tools in state criminal investigations. There will be no doubt be considerable debate on what may or may not need to be changed. But there will also be debate on how any needed change should be effected. I look forward to the witnesses today, and I look forward to having you start the debate. Let me say it won't be the end of the debate.
In the interest of getting to our witnesses and mindful of our busy schedules, I ask that other members submit their statements for the record. Without objection, all members will have 5 legislative days to submit opening statements for inclusion in the record. Without objection, the chair will be authorized to declare a recess of the hearing. We will now turn to our first panel of witnesses. In fact, our only panel of witnesses. Jim Dempsey is Vice President for Public Policy at the Center for Democracy and Technology, where he concentrates on privacy and government surveillance issues. Mr. Dempsey coordinates the Digital Privacy and Security Working Group, a forum for companies, trade associations, think tanks, and public interest advocates interested in cybersecurity, government surveillance, and related issues. He received his JD from Harvard Law School. Additionally, Mr. Dempsey was counsel to this subcommittee under Chairman Don Edwards. He continues to carry on that work at CDT, and I'm pleased to welcome him back. Albert Gidari is a partner at Perkins Coie, I think, LLP, where he represents a broad range of companies on privacy, security, internet, electronic surveillance, and communications law. His practice also includes both civil and criminal litigation, investigations, and regulatory compliance counseling. He is a graduate of the George Mason University School of Law. Orin Kerr is a law professor at George Washington University who has written extensively on the Electronic Communications Privacy Act. From 1998 to 2001, Mr. Kerr was a trial attorney at the Computer Crime and Intellectual Property section of the U.S. Department of Justice. He earned his J.D. magna cum laude from Harvard Law School. Annmarie Levins is an Associate General Counsel at Microsoft Corporation. She manages the legal support for Microsoft's U.S. and Canadian subsidiaries, directing the legal teams responsible for licensing and service transactions, anti-piracy investigations and enforcement, internet safety work, and other areas. Ms. Levins formerly served in the U.S. Attorney's Office in Seattle and in the Southern District of New York. She graduated summa cum laude from the University of Maine School of Law. I'm pleased to welcome all of you. Your written statements in their entirety will be made part of the record. I'd ask each of you to summarize your testimony in 5 minutes or less. There's a light in front of you. When it turns yellow, that means you have a minute left. And I will advise you that the chair is somewhat lax or latitudinarian maybe in interpreting the the time limits. Before we begin, it's customary for the committee to swear in its witnesses. If you'd please stand and raise your right hands, take the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief?
I do.
Let the record reflect that the witness has answered in the affirmative. You may be seated. And I now recognize Mr. Dempsey for 5 minutes.
Chairman Nadler, members of the subcommittee, good afternoon. Thank you for holding this hearing. In setting rules for electronic surveillance, the courts and Congress have long sought to balance three critical interests: the individual's right to privacy, the government's need to obtain evidence to prevent and investigate crimes and respond to emergencies, and the corporate interest in clear rules that provide confidence to consumers and that afford the companies the certainty they need to invest in the development of innovative new services. Today, it is clear that the balance among those three interests has been lost. Powerful new technologies create and store more and more information about our daily lives. The protections provided by judicial precedent and statute have failed to keep pace. The major federal statute setting standards for governmental access to communications, the Electronic Communications Privacy Act, or ECPA, was written in 1986, light years ago, in Internet time. Among other key points, private information directly analogous to a telephone call or a letter now falls outside of the traditional warrant standard when stored online. As a result, a major section of ECPA is probably unconstitutional in many applications. Every witness at this table today agrees that ECPA is outdated and needs to be reformed to provide strong privacy protections while also preserving the tools that law enforcement agencies need to act quickly to investigate crimes and respond to emergencies. For the past several years, the Center for Democracy and Technology, my organization, has been chairing a dialogue among leading Internet companies, communications companies, privacy advocates, law professors, and attorneys in private practice to discuss how ECPA was working and how it needed to be updated. We had, as part of our group, several former prosecutors and several alumni of the Computer Crime and Intellectual Property section at the Department of Justice. In our discussions, we were acutely aware of the needs of law enforcement. We started with a list of over a dozen issues. Some of the privacy advocates and scholars wanted to go farther in strengthening the rules, but the former prosecutors emphasized the importance of preserving a sliding scale of authorities. We met monthly and then even weekly. Ultimately, we reached consensus on 4 principles: consistent application of the warrant standard to private communications and documents, consistent application of the warrant standard for location tracking of cell phones and other mobile devices, true judicial review of pen registers and trap and trace devices, and we can go into more detail about what pen register trap and trace devices are and how they work, and no blanket use of subpoenas. Now, in some ways, many ways actually, these proposals are modest. The proposals would preserve all current exceptions, including the emergency exception that permits disclosure of email and other content without a warrant, even without a subpoena, in times of emergency. We do not propose any changes to FISA or to the national security letter provision in ECPA. Our proposals on email and stored documents focus solely on compelled production from a service provider providing service to third parties. We do not propose any change to the rules governing how you get information directly from the subject of an investigation. A company could not hide behind ECPA if the government is investigating that company. The rules permitting subpoenas served directly on targets of an investigation will remain unchanged. As Chairman Nadler indicated, that the companies and organizations endorsing this principle call themselves the Digital Due Process Coalition. The coalition now includes major internet and communications companies, major think tanks, and advocacy organizations ranging from the ACLU to Americans for Tax Reform and FreedomWorks. We are continuing to add new members each week. We see our principles as the first step, and I emphasize this, just an opening framework in a process that will require public discussion, the engagement of other stakeholders, and most importantly, dialogue with law enforcement agencies. We have already begun the process of discussing these principles with the Department of Justice, the FBI, and the National Association of Attorneys General. We intend to get very specific in follow-up discussions, addressing concrete hypotheticals about how updates to the law would affect ongoing practices. Mr. Chairman, the Coalition is not urging the introduction of legislation. Many details remain to be discussed before we get to the legislative phase. Other issues might be brought forward in addition to the 4 that we've put on the table. We urge this committee, and we're urging the Senate Judiciary Committee, to move cautiously, to hold further hearings, as you already indicated you would, to listen to the views of law enforcement, of the telephone companies and other carriers. Professor Kerr, in his testimony, has proposed some excellent questions that need to be and can be addressed and resolved. Some of them, speaking for CDT, I have answers to. Others of them, I don't have answers to yet, but we agree they need to be addressed. Our coalition foresees a long-term process of hearings, dialogue, and consensus building. Together, though, we can reestablish the balance among those interests that were critical in 1986: law enforcement, privacy, and business. I look forward to your questions, Mr. Chairman, members of the subcommittee. Thank you.
Thank you. Mr. Gidari is recognized for 5 minutes.
Thank you, Mr. Chairman, committee members. It's a pleasure to be here. Today I appear as an individual not representing any particular service providers or clients, but over 15 years I've had the pleasure of working with many in industry in their implementation and compliance with ECPA and the Communications Assistance for Law Enforcement Act. These service providers are caught in the middle every day. The best way to determine whether ECPA is out of balance is to take a look at what service providers do every day, and that is essentially guess. They try to understand what the law requires and implement it on a daily basis. But because the law relies so much on definitions like an electronic communications service provider to the public or a remote computing service provider to the public, service providers have to understand how the law applies to them and the legal process they need to disclose user communications and information. If they don't understand the bright line rule, then mistakes can be made, and those mistakes carry real consequences. We have cases, one heard just recently in the U.S. Supreme Court, where the service provider guessed wrong, thinking it was one thing when it was another, and disclosing communications on a lower standard than it should have, and therefore being liable for that privacy breach. That is an untenable position for the men and women of service provider security offices who every day deal with these requests from law enforcement and understand that those requests are valid, important, and sometimes life-threatening, but yet they also have user privacy concerns, and they must meet that imperative to protect user information. So it's an untenable position for them. They have a real identity crisis about what they are today, when in a social networking environment, you could be just as easy an electronic communication service provider as a remote computing service provider, and who knows, under the definition, what you are. It is a very difficult position. So we know it's out of balance, and we know clarity is important. As much as the academic debate about what the right standard is interesting, it isn't as interesting to service providers as having a clear rule. So if there's anything that can come out of this hearing and future hearings, clarity is first and foremost. I'd like to observe also with location-based services, for 15 years, I've worked with wireless carriers in their response to law enforcement requests to use what is a remarkably robust and important tool for law enforcement: tracking capabilities, the ability to find a bad person or a kidnap victim in real time, as quickly and as efficiently as possible. It's a great capability. But right now it's a muddle. Service providers haven't got a clue what the right legal standard is. And within the same judicial district, you might have two magistrates who disagree and issue contrary orders for the standard upon which to disclose that information. And what information should be disclosed? How often? How frequently? It's not uncommon for law enforcement to ask for a phone to be pinged every 15 minutes. In a lot of ways, service provider security offices and their personnel feel like they're the customer service of some computer organization, having to respond to incessant and continuous requests. Now, they're important requests, but the fact is the law does not state how often, how frequently, how rich, how detailed, and to whom that information should be provided. The service providers simply need the clarity to understand what to do. Lastly, I'd like to just observe that in ECPA there are some areas for improvement on transparency. It's difficult to make policy if one doesn't know how much information is collected. And from a personal perspective, dealing with the volume of requests every day, this committee and the public would do well to have clear numbers before them. The number of user records requested on a daily basis is astronomical. We can commend Google, who recently published through their transparency project a list of statistics that show the number of requests that they receive on a regular basis. Those numbers are dwarfed by the number of requests that service providers like wireless carriers receive every day. Just yesterday, the courts, administrative courts, released the wiretap report. And that annual report tells you the number of wiretaps conducted each year. For the past year, 2009, the numbers went up 26%. There's some good in those numbers. The U.S. stacks up pretty well compared to the rest of the world. If all we had was 2,600 total federal and state wiretaps last year, somebody's doing something right in reviewing them carefully and not overusing them. Unfortunately, we don't know how many pen registers have been implemented. We don't know how many location orders are implemented, and we certainly don't know how many user records have been asked for, used, and how long those are retained. If we could do anything to improve ECPA and its transparency, the collection and publication of that data would go a long way to helping the committee make decisions on good, sound policy. Thank you, and I hope to answer any questions you have.
I thank you, and I now recognize Mr. Kerr for 5 minutes.
Chairman Nadler, members of the subcommittee, thank you very much for the invitation to be here today. I think it might help to start with understanding why we're here. In traditional criminal investigations, the police do the work on their own. They walk the beat, they conduct their own searches. If they see evidence of a crime that they think they need, they take it. They don't work with providers, they don't work with anybody else, they make all the decisions on their own, sometimes pursuant to judicial review by a judge, but not with the work of any private parties. The opposite is true with new online crimes, crimes committed using networks, whether it's the internet, crimes committed using telephones, or simply a case where there happens to be evidence that's stored or available over some sort of a network, whether the internet or the cell network. In all of those cases, the government is working through the intermediary of the provider. There's a company that runs a network that has data. And the real question, and the question that the Electronic Communications Privacy Act is designed to address, is what should the rules be when the government wants data that the network has, or when the network company, this third-party provider, wants to disclose information to the government. Now, that means that in order to understand the issues raised by ECPA, we need to think about what the data is, and when does the government obtain it. So it may be helpful to think about two different kinds of data that the communications providers may have. One category is contents of communications. That's the actual message that somebody may be sending or receiving over the network. Might be an email, might be a text message. In the case of a phone call, would be the actual conversation the two people are having. And then there's lots of non-content information. The non-content information is information that the network is generating and using in order to deliver the communication. Now, we can understand what kind of contents a network might have because we, as users of the network, are aware of that. If somebody sends you an email, for example, you know that the email is there. Non-content information is quite different. The amount of information that may exist depends on the technology, depends on the network, may depend on the company, depends on business decisions that each company is making as to whether to keep records, whether to generate certain records. And that means there are lots of records available, and those records may vary dramatically based on the company and based on the technology. So that's the issue of what the records are that are out there. The next thing you need to think about is, when is the government collecting the information? So again, we can think of two basic categories. The one category would be when the government comes to the provider and says, we're going to compel you to disclose certain information. We want you to act on our behalf as our agents, essentially, and provide certain information. Maybe it'll be stored contents that the government wants. Maybe it will be stored non-content information that the government wants, these records. And other times, the government will want real-time surveillance to occur, sometimes of contents in the case of wiretapping, sometimes in the case of non-content information, for example, where somebody's cell phone is located or who somebody is emailing. So that's the case when the government is compelling information. And then the flip side of that is, what if the provider comes across evidence and wants to disclose it to the government? Maybe the provider has uncovered child pornography. Maybe the provider has discovered some evidence of some other crime and wants to provide that information either to the government or even to a non-government group. What should those rules be? That's the question that the Electronic Communications Privacy Act was designed to address in 1986. Now, of course, in 2010, technology has changed dramatically. And I'm very glad to hear that the committee has planned more hearings. Because I think what really we need to hear from is, we need to hear from these providers. We need to find out, what information do they have? What are their practices? What is the technology? How does it work? What kind of cell phone location information do different providers have? How close can they get to finding out the location of a user of a phone? How long do they keep their records? So we need to find out from the providers, what are their practices? And then we also need to find out from the government, how do their investigations work? Those of us that watch a lot of television know we've seen a lot of Law and Order, and we know how those investigations work, or at least how they work on TV. But mostly we don't know how these new online investigations work. We haven't seen those investigations. Very few people have. So we need hearings to talk about not only the technology, but what are the kinds of cases that the government is working? How do these cases actually unfold? And I think it's only after getting that informed sense of what the technology is and how the investigations actually work that the committee can think about, what do these rules need to be like? How do these rules need to change? It's been a quarter century since ECPA was passed. And it's time to think about how the technology has changed and how to balance the security interests and privacy interests given the technology of today, not the technology of 1986. So I'm very glad that the committee is interested in these issues. Obviously, today's hearing is just the tip of the iceberg. There's a lot that we can talk about. But I think starting off by recognizing that this problem exists, both in terms of the new technologies and these new types of investigations, is a very important first start, and I'm happy to be here. Thank you.
Well, thank you, and we'll now recognize Ms. Levins for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, members of the subcommittee, my name is Annmarie Levins. I'm an Associate General Counsel at Microsoft. I manage the legal support for Microsoft's U.S. and Canadian subsidiaries. My team is responsible for contracts with our customers and partners, for anti-piracy and digital crimes investigations, for Internet safety work, and other areas. Before joining Microsoft in 1998, I had the privilege of serving as the Assistant United States Attorney in Seattle for 3 years, and before that in the Southern District of New York for 7. During my 10 years as an AUSA, I worked with many smart, dedicated law enforcement officers investigating organized crime, racketeering, narcotics, and financial fraud cases. Thank you for this opportunity to share Microsoft's views on the reform of ECPA. Microsoft is in a unique position to comment on the need for ECPA reform. We have offered Internet-based services for almost 15 years, dating back to MSN's dial-up Internet service. We have offered Hotmail, our free web-based mail service, since 1997. Today, we offer a full array of cloud computing services, including our hosted suite of enterprise-class email, relationship management, and collaboration tools, and our cloud-based storage and computing resources called Microsoft Azure. Our customers range from individuals to small and medium-sized businesses to some of the largest multinational corporations in the world. From our vantage point, we have seen how the technologies governed by ECPA have evolved over the years since its enactment and the tremendous potential these technologies represent for all of our customers. Today, users can store documents, data, and communications to central locations and access them anywhere in the world on a wide variety of devices, including laptops, phones, and other forms of personal devices. Increasingly, web-based accounts are used interchangeably with local storage devices. As these internet-based resources become part of our everyday computing experiences, users may not even realize that the legal protection afforded their data and documents are not necessarily the same when they use third-party storage and processing capabilities in place of their own computers or networks. While there has been a fundamental shift in the amount of sensitive information that we now trust to third parties, the law has not shifted in parallel to preserve reasonable privacy interests. Quite simply, the basic technological assumptions upon which ECPA was based are outdated. The nature of the protection afforded to stored electronic communications has not kept pace with the many innovations in online computing over the last 24 years. For example, ECPA extends greater privacy protections to emails stored for less than 180 days than emails stored for more than 180 days. This distinction might have made sense in 1986 when email services did not automatically retain messages for long periods of time. But the distinctions no longer bear any relationship to reality. Hosted email and other online services regularly store emails and other content for years, and users today reasonably expect these communications to remain just as private on day 181 as they were on day 179. Microsoft believes that now is the time to address these issues. We are on the verge of a transformative age in internet cloud-based computing. Cloud computing services can increase efficiencies for business and government, lower IT costs, create energy savings, and spur innovative job-creating enterprises. They will enable small and medium-sized businesses, individual entrepreneurs, and other innovators to tap into computing resources that previously had only been available to the largest companies and at a fraction of the cost. These capabilities can drive innovation, make America's businesses more competitive, and ultimately contribute to economic growth. But unless we are able to preserve and protect users' privacy interests to meet their reasonable expectations, adoption of cloud computing services may be limited, and the full potential of cloud computing may not be realized. Indeed, in a recent poll conducted for Microsoft, more than 90% of the general population and senior business leaders said they were concerned about security and privacy when they contemplated storing their own data in the cloud. This is among the reasons why Microsoft joined the Digital Due Process Coalition in the launch of a new initiative to update ECPA. We understand the importance of supporting lawful investigations and spend significant resources every year to help make the online environment safer for all users. The Microsoft Digital Crimes Unit that I oversee was created specifically to assist law enforcement in pursuing digital crimes and to provide training to prosecutors and investigators around the world. In conclusion, Microsoft believes that the decisions about the right balance between users' reasonable expectations of privacy and law enforcement's legitimate interests should be made by Congress with input from all key stakeholders rather than as a result of unanticipated shifts in technology. We view the Digital Due Process Coalition's proposal as a good starting point for Congress's inquiry. Ultimately, smart, targeted reforms of ECPA are essential to restore a proper balance between privacy and law enforcement in the digital age and will help cloud computing fully deliver on its promise. Thank you for the opportunity to testify today. On behalf of Microsoft, we appreciate this committee's leadership in addressing these important issues, and we look forward to working with you.
Thank you. The witnesses having completed their initial statements, will turn to questions, and I'll begin by recognizing myself for 5 minutes. Mr. Dempsey, are any of the digital due process principles intended to change a service provider's ability to share information with law enforcement in an emergency?
Absolutely not. We make it clear that there are emergency exceptions in the law right now which permit disclosure of information without a warrant, without a subpoena in emergency circumstances, and we would leave those untouched.
Thank you. Ms. Levins, you indicated in your testimony that ECPA relies on outdated notions of how individuals and businesses interact with information technology. I assume, among other things, you're talking about, well, we know you're talking about cloud computing because you mentioned it specifically. Can you tell us more about cloud computing and why this technology is, quote, transformative, unquote, and what benefits does it offer to society, and how do we support such technological progress as we attempt to balance the interests of privacy and law enforcement? All in about 2 minutes.
Thank you, Mr. Chairman. I'd be happy to address that. Cloud computing is important because it opens the door for everyone to use the most powerful computing capabilities there are. It used to be that you couldn't afford to buy that kind of computing capability and storage unless you were a big company. But now you can use your desktop, your laptop, and use storage facilities that are maintained by a third party to do that kind of computing and storage that was previously unavailable on your home network.
Storage or storage and computing capacity?
Both.
Both.
Both. So that's the first part. I mean, and I think that opens doors to all kinds of businesses to expand the way they do business in ways that weren't even thinkable when ECPA was passed in 1986.
And what do you think the implications for the development of cloud computing are if government access to email content stored in the cloud continues to be subject to a legal standard different from that applied to other forms of data storage?
And I think that's a critical question, because what we found and what our poll showed is that people are very concerned that by putting data in the cloud, are they going to have the same level of privacy and security that they would have if they maintained it within their own four walls of their company or home? I think that they will be reluctant to move to the cloud and take advantage of this opportunity if they aren't assured of what the standard of privacy is and it doesn't meet their reasonable expectations.
So we have to make sure that there's a standard of privacy equal to what there would be on your personal hard drive, or just a certainty that people know at some other level?
Well, certainty is important, but I think, in fact, if you're talking about content, people expect that what they would have on their hard drive, in their personal hard drive, should be protected in the same way. I put it the other way. The information in the cloud should be protected in the same way that their
to the same legal standard.
hard drive would. And that's particularly true, I think, of corporations.
Now, but the importance of maintaining privacy in the cloud is what you just said, but we have to maintain security in the cloud too. How do you balance them?
Well, I don't think they're inconsistent. And Microsoft, for example, has taken lots of steps to make sure that we have the best security that we can. And we are constantly working towards meeting the highest standards that are recognized in the industry. We think one of the most important things that could happen in this area is to have greater transparency about the security practices that companies offering cloud services are adopting and using. So it goes hand in hand with privacy. Users want to know that their information is safe, and they want to know that it's being secured and their privacy is being secured.
Thank you. Professor Gidari, Mr. Gidari, you indicated in your testimony with respect to location-based information that there has been a magistrate's revolt for several years. Can you describe what you mean by this phrase and in what ways, if any, it has been fomented by the government's interpretation of ECPA?
Yes, Mr. Chairman. Over the last 3 or 4 years, a number of magistrates have objected to automatically approving, as part of pen register orders, requests to disclose the location of a cell phone in real time, prospectively, on an ongoing basis. They objected to using the pen register standard alone or in combination with what is known as a specific and articulable fax order, or as the government calls it, a hybrid order, to authorize that disclosure. Other magistrates disagree and believe that standard is acceptable, but about a 3-to-1 ratio, these magistrates have believed that a probable cause standard is necessary to track and follow an individual. And that mini revolt, if you will, has resulted in very inconsistent standards within judicial districts. Is a magistrate sitting next to another magistrate could completely disagree and have disagreed, issuing orders that have different standards. So one person might be tracked according to one standard, another one to a higher standard, and then within the states themselves, the ECPA, of course, sets the floor.
But you'd get that in any event, and even if we wrote a standard in law, a more specific standard, you would get judges disagreeing with that, and until it went up to the circuit or the Supreme Court, you'd have judges sitting next to each other issuing different decisions, no?
You certainly would. From a service provider's perspective, which rule applies, which order should pertain, what responsibilities do they have to their users to object to that order. The rules for location information today just simply don't state under...
So they should state it more specifically.
Absolutely.
Mr. Dempsey, you look like you wanted to comment on that.
I'm just saying that right now you sort of have an open fields or green field sort of no guidance at all.
So we need statutory guidance.
The statute would, we would try to make it as specific as possible and precise as possible, but at least it would provide some context within which the courts would operate.
Thank you. My final question is to Professor Kerr. In some of your recent scholarship on applying the Fourth Amendment to the Internet, you talk about replacing the inside-outside distinction, common to Fourth Amendment jurisprudence, with a content-non-content distinction. Can you tell us what this means and how you believe it extends consistent application of the Fourth Amendment principle to cyberspace? And is the analogy perfect, or does it give rise to any notable exceptions we should be aware of?
The basic idea here is when courts are considering how to apply the Fourth Amendment, which was created for a physical space, to a network environment, they should think about how to create a set of rules that tries to replicate how the Fourth Amendment applies in the physical world to this network space. And the basic idea is that the contents of somebody's communications, these actual messages, are the online equivalent of stuff that would happen inside and would be protected by the Fourth Amendment in the physical world. On the other hand, the non-content information that a network creates is essentially the online equivalent to transactional information that would have occurred outside in the physical world. Now, if you follow that idea, the basic idea is that networks are doing for us what we used to do in the physical world, basically the network is coming to us instead of us having to go out into the world. And the idea is it creates a rough parallel between how the Fourth Amendment should apply in the physical world and how the Fourth Amendment should apply on the internet. Now, of course, it's just a law review article. We don't know whether courts are ever going to follow this. And in fact, there's a Supreme Court case right now, Kwan versus City of Ontario, in which the Supreme Court is trying to figure out for the first time, how does the Fourth Amendment apply to text messages? I went to the oral argument, and the justices were as puzzled about this question as anyone could be. So we're just trying to figure out these issues, and the idea of the content-non-content distinction is just an initial first start to try to figure out how the Fourth Amendment should apply, and by analogy, how the statutes could be drafted to recognize the stronger protection for content and for non-content information.
Thank you very much. My time has expired. I'll now recognize the distinguished gentleman from North Carolina.
Thank you, Mr. Chairman. I think I will acknowledge at the outset how ill-prepared technologically I feel to engage in this discussion. Ill-prepared, yes. I feel like Neanderthal in this area. So let me, I want to ask a couple of questions and then I just want somebody to give me some examples of the kinds of things that are going out there that we should be worried about given the failure to update the statute. But let me talk about process first. Mr. Dempsey, you talked in your testimony about a long period of dialogue and consensus building being needed. Mr. Gidari, you seem to suggest, although not explicitly, that clarity was more important than substance of where you get to. So I'm trying to figure out how long we should be working on this, before we get to some kind of legislative solution. Is clarity of a rule more important than getting the rule right, the new standard right? What kind of time are you talking about for dialogue and consensus building, Mr. Dempsey? And does that fit with your urgency for clarity, even if the clear standard is the wrong standard?
Well, honestly, I think, my own time frame is if a year from now we could be here with a piece of legislation that would be, a markup or something a year from now would be a good target. But I think it is going to take a while. We're not pushing, as I said, for introduction of legislation immediately. I think we do have, and as we go through this process here, we do have some touchstones, and we can think about some of the analogies. They only take you so far, but they help. Take what we're talking about in terms of cloud computing. If you have a document on your computer in your office, or if you have that document printed out, that's protected by the Fourth Amendment. Persons, houses, papers, and effects, I think nobody has any doubt that papers includes your laptop. If, however, as now, and by the way, if you...
Wait a minute now, you're going to take my whole 5 minutes talking about something that I'm trying to find. You say a year from now, and let me give Mr.
I do want to come back to the question here of what are the guideposts we have that get us both the clarity...
I'm just talking about the time
substance.
frame now. I'm not even talking about what the content is. Is a year from now too long from a clarity perspective, Mr. Gidari?
I think lawyers will find ambiguity in a no smoking sign for the rest of our lives, but if that's the case, fix it right. If it takes a little longer to do that, we would rather have it right than wrong, but that doesn't mean they're inconsistent.
So the real question I'm trying to get to is what risk do we run in this interim, and that's where I get to the second part of the question. I mean, what are the horror stories that are going on out there? I mean, give me a couple of concrete horror stories that's going on in this interim while we're trying to either build consensus or get the standard right.
Well, here's one example. Every one of us probably has 5, 6, maybe 10 years worth of email stored, either stored on our local computer or often stored with a service provider like MSN or Gmail or another provider.
Somewhere in a cloud.
That data is stored on a remote.
Which I never heard of until today, but that's all right.
We're talking here just about, when people used to draw a picture with a computer over here and a computer over here and then a cloud in the middle, that internet server.
I get the concept.
And that's where a lot of our data is going. The way ECPA now works, it says that email 180 days old or less is protected by the Fourth Amendment warrant standard. The minute it turns 180 days old, it's available with a mere subpoena issued without judicial approval. The Justice Department takes the position that the minute that email is opened at all, in fact, from the sender's perspective, the minute it's sent, it loses its warrant protection. Fully protected passing over the wire, the minute it reaches, you finish sending it, or the minute the user, the intended recipient, opens it and looks at it, falls outside of the protection of the warrant. Same document, if you print it out, leave it on your desk, protected. Same document, you put it in a box and you lock it in one of those storage lockers out in the suburbs, protected by the Fourth Amendment. But locked up in the cloud, not protected by that requirement. In the Ninth Circuit has rejected the Justice Department view and has said that a warrant is required. So what happens now is, if the warrant is subject to the jurisdiction, or the subpoena is subject to the jurisdiction of the Ninth Circuit, it's rejected and a warrant is required. If it's outside of that, it's a little unclear. In Colorado, a month ago, the Justice Department sought email without a warrant. Yahoo said no, go get a warrant, even though we're outside of the Ninth Circuit. The Justice Department backed down, said, okay, withdrew the request. That's the kind of uncertainty you're getting. Now, and there is overarching it all the possibility that these cases will percolate up through the courts and that the statute will be held unconstitutional if the Justice Department pushes its position.
Because it's too vague?
No, because the warrant is not, where the statute currently permits access without a warrant, if Professor Kerr is right, that a warrant is required, that content is like a letter, it's like a phone call, it should be protected. So you do run that constitutional risk. I still agree with Mr. Gidari in my initial statement that, you know, we've lived with that ambiguity now for 5, 10 years. I just don't see how we're going to push this forward. Given the law of unintended consequences, we want to make sure we don't screw things up worse.
Thank you. I'm way over my time, so I'll yield back.
In that case, we will recognize the gentleman from Virginia for 5 minutes.
Thank you, Mr. Chairman. Mr. Dempsey, it seems to me that a person doesn't think any different about an email saved in the cloud as on the computer. Why would the email in the cloud be any different than the email stored in that storage bin in the suburbs that you talked about?
I don't think it should, and the conclusion that we came to in our preliminary dialogue is that it shouldn't. If you go back to 1986, I think what you end up with is this was a distinction based upon the way the technology worked in '86. Storage was expensive, and service providers did not store email. If you go back to the early days of AOL, you read it, you downloaded it, it was deleted from the computer of the service provider. Congress thought 180 days would be the absolute conceivable outside limit. And after that, it was sort of like abandoned property or a...
Well, once it gets into the cloud, who has can anybody get access to it? Besides, could I look into
No.
Representative Watt's cloud?
It really is. The cloud actually is potentially more secure in some ways than local storage. You have the service providers of cloud storage capabilities making a lot of effort to secure that.
So this is being kept in a place that is secure from anybody else, and it's just I'm the only one that can access my part of this cloud.
You are the person to whom
so I
you
have an
give consent.
expectation that this is private information.
That's certainly the way the average person looks at it. That's one of these changes that has occurred, the technology changes that have occurred in the past 10 years that we're talking about.
Ms. Levins, when Microsoft has to respond to a lot of warrants and subpoenas, it costs money. Does the government incur any of the expense, or do they just let you worry about it?
Congressman Scott, that's not my area of expertise. I'd have to get back to you with that information. I know my colleagues do know that. I don't have that with me. Sorry.
Does anybody know what?
The statute authorizes reimbursement for non-toll records. So phone companies give them away for free in large amounts, but electronic communication service providers are entitled to charge for them. Not all of them do. Many provide that service to law enforcement for free. Others charge the reasonable cost.
Some information can be obtained fairly easily. Some takes a little complication where you have to program the computer and pay expenses to get the information, and some of it, I imagine, gets kind of expensive after a while.
That's right.
And you can charge for that expense?
That's correct.
Does anybody have any concern if we keep talking about how government does all this surveillance? that we might publicize their techniques and compromise some investigations?
I've always thought that we could have the discussion without compromising techniques. I think we can talk at the level of specificity necessary to draft a clear statute, incorporate the Fourth Amendment principles, and do that in a way that doesn't get into the technology at all. In fact, technology neutrality, I think, is one of the principles that we're trying to achieve here.
Okay, and with the pinging the cell phone, can anybody ping somebody else's cell phone, or is that just something the company can do?
It's something only the company can do.
And I think there's an expectation that you're not being followed because the company isn't supposed to be following you around. And the only way the government can do it is, what does the government need to order the company to find out where you are?
Depends on which magistrate you visit, but at least a pen register order and a specific and articulable fax order combined. But in many jurisdictions, a probable cause warrant issued under Rule 41.
But for a government request, I should have an expectation that I'm not being pinged and shown up on somebody's computer screen. Is that a reasonable expectation, or
That's more than a reasonable expectation.
And that is the way I think that the carriers have designed their services. A number of carriers offer services whereby parents, for example, who are the subscribers to the service, can find out, for example, where their children are. But that's a case of the subscriber controlling their account. There are a variety of services now being offered where I can share my location with my friends. The companies who have designed those services have been very, very careful to design them in a way so that the user has control. To override that user control, the company has to be involved. The company has to be compelled to do something. And some of those services offer very, very precise location capability, in essence almost pinpointing a person on a map. A number of those companies have said that they will insist upon a warrant for disclosure of that information, and I think they have a strong constitutional argument for that. But the statute, as we've said, is completely unclear.
Thank you. I'll now recognize the gentleman from Georgia.
Thank you, Mr. Chairman. If I were someone's wife, and I was out on the town running around with all kinds of males and females and engaged in doing my own thing pretty much out, and I'm wanting to keep all of that secret, I'm certain that no one on the panel would want the husband of, or they would not want my husband to be able to go to the phone company and say, look, I need to find out where my wife is because I'm going to kill her when I find her. None of you all would want that to happen, would you? So nobody's saying anything,
No.
so I assume, okay. All right. And now, what if I were a law enforcement officer, the husband? Or what if my husband was a law enforcement officer? Is there any, and only thing this law enforcement officer did was to go get a subpoena, which he carries around, blank subpoenas, and comes to a cell phone provider and says, look, I'm conducting an investigation and you must provide this information to me. Should that law enforcement officer or any other law enforcement officer be able to obtain that information, the whereabouts of his wife?
They'd be shown the door with that request, the door to the courthouse, where they would have to ask a judge to approve an order to get it.
But that may be true at your cell phone company, but it's not necessarily compelled by law that the cell phone company refrain from producing those documents. Is that correct?
Congressman, there's actually an interesting case that has emerged in the 11th Circuit recently, which dealt not with the location information, but instead with some emails. And the case clearly involved a certain amount of favoritism on the part of the prosecutor and the sheriff in that area, who at least allegedly were doing a favor for a friend in defending that friend against some civil litigation or some civil controversy, issued a subpoena, like you say, served the subpoena on the service provider, and the service provider did turn over that email. The case has gone up to the 11th Circuit, and unfortunately, this is one of the cases that I think went in the wrong direction. Professor Kerr has also written about it, criticizing the decision in this case. But the 11th Circuit held that there was zero constitutional privacy interest in that email, and that the sheriff and the prosecutor, in essence acting off on their own, had not violated anybody's rights.
So, and the reason why it was not private is because it was in the cloud somewhere?
Yes, there was this notion that they had, which we think is wrong, that the privacy was lost because of the use of that technology.
Yeah. Is there anybody who would agree with the 11th Circuit decision in that case that's sitting on this panel? Yeah. Okay. All right. Well, you know, I've been sitting here all day trying to find something that someone on the panel would say that would incite me to issue forth with tough questions, but you all have deprived me of that option, and I'm pretty much, I guess, singing to the choir when I say that I would hate to see, either with content or with non-content information requested by law enforcement, to use your analogy, Mr. Carr, or not your analogy, but your terminology. I would hate to see a company turned into an agent for law enforcement at the expense of their customer. It's so, to me, the issues that we confront are easily dealt with by legislatively extending the Fourth Amendment, and I do believe that there is an inherent right to privacy, which is implied in really the first 9 amendments, but certainly the Fourth Amendment. All we have to do is just extend it to these new areas that have come to the fore since we have been embarked on this pursuit of intellectual supremacy, if you will. This is just human nature, but if we stick with the ideals of the Founding Fathers, particularly with respect to the Fourth Amendment, I think that our job should be easy. And I guess there could be an argument that we just leave each case up to the courts to flesh out, and ultimately to the U.S. Supreme Court. But I'm afraid that we would. I'm afraid to leave it up to the U.S. Supreme Court when we can put those things into legislation, which clears up the ambiguities that may arise. So I think this is a very important hearing. It bears upon the individual rights that we in this country oftentimes take for granted, but they are what make America what it is. So thank you very much. And I noticed that the chairman is now thinking pensively as we proceed.
And you yield back?
At this time, yes.
Then I will recognize the gentlelady from California.
So, Mr. Dempsey, I would like to ask a question about the fate of an email that I would send out, but under different circumstances with regard to privacy and the Fourth Amendment. Let's just say I email a friend, Sarah, and what would happen to the fate of that email if she's read it versus hasn't read it, or with regard to if 8 months have passed versus tomorrow, whether it's on a Gmail account or whether it's on her hard drive, or what if I took the content of that information and put it in a letter and just mailed it?
In the Appendix A to my testimony, I talk about this example, and if I was better with graphics, I would have tried to do a chart that showed this, because it really does almost take a matrix to explain this. While the email is in transit, moving over the wires, so to speak, or moving through the network, it can be intercepted only with a warrant, a wiretap order issued under the Wiretap Act. Once it reaches the inbox, so to speak, the computer of the service provider of Sarah, the intended recipient, it comes under the Stored Communications Act, and at least until she opens it, that email sitting in her email box is protected again by the warrant requirement. After she reads it, under my reading of ECPA, for 180 days it remains protected by the warrant requirement. After 180 days, on day 181, it loses the warrant protection. So you go from warrant to non-warrant. An interesting example is if you're using Gmail, by the way, and you, or any other remote web-based email service, and you draft your email and don't send it, because you haven't finished it, you're going to come back the next day and finish it and send it. While that email is sitting on the server of Google, it's available regardless of age. It's available with a mere subpoena. It's not protected by the warrant at all, because it's Google is at that time acting as a provider of remote computing services, not as a provider of electronic communication services. They're storing the email. Once 180 days passes, then Google again reverts to its status as a remote computing service. It's available with a subpoena. The Justice Department argues that the copy of the email that you might store, since you store all your outgoing email, if it's stored in the cloud, loses its protection as soon as you send it, because it's no longer in transit, in temporary storage, incident to transmission. It's sort of your copy. Now, if you had printed out a copy and kept the copy in your office, that's protected by the Fourth Amendment. If you have a copy on your desktop or laptop, that's protected by the Fourth Amendment. But the copy that is stored on your account, according to the Justice Department, from the minute you push send, that is not protected by the warrant.
Would the gentlelady yield for a moment?
Yeah, yes.
And the Justice Department, in effect, is saying that because you press the send button, the Fourth Amendment doesn't apply because it's no longer your papers?
It applies only, I think everybody would admit that it applies to the email in transit.
But why doesn't it apply continuing?
They argue, I think, that it's it's hard to articulate their theory. It is a stored record, in their opinion, that has been entrusted to a third party in such a way that you have surrendered your privacy interest in it. Now, I think the correct analogy is the storage locker analogy, in which a warrant is required to go into the storage locker. There are cases they analogize it to something like a check, a canceled check, which goes to the bank.
And that's even more strange when they say that it's not protected by the Fourth Amendment before you finished it.
If you store it with if you leave it on some remote server.
I thank the gentlelady for yielding.
And so if you have it on the hard drive, it's protected, but if it's in the clouds, it's not protected. And if it's a letter, I'm presuming you're saying it's protected.
The letter is interesting because the letter is protected, of course, in the hands of the post office. Goes back to 1877 when the Supreme Court ruled that the Fourth Amendment does protect the letter moving through the mail system. The copy of the letter that I retained is protected. The copy of the letter that the recipient has is protected. Vis-a-vis the recipient, they can always voluntarily turn it over, but to force them to disclose it would require a warrant or a subpoena served directly on them. So you've got this crazy quilt that the average individual has absolutely no idea about. And increasingly, the services are being designed in a way to make all this completely seamless and completely non-apparent to the user. So we have these increasingly powerful Blackberries and handheld mobile internet devices. We're constantly accessing information remotely. Sometimes it's on the device, sometimes it isn't. Increasingly, it becomes even less clear where it is, and it's time to dispense with these technology-based, platform-based rules by which people do not lead their lives anyhow. People do not base their lives on these distinctions from 1986.
Thank you. I yield back.
I thank the members of the panel, unless any member of the panel wants to say anything else. In which case, without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask the witnesses to respond as promptly as they can so that their answers may be made part of the record. Without objection, all members will have 5 legislative days to submit any additional materials for inclusion in the record. Mr. Dempsey, you wanted to say something?
Yeah, Mr. Chairman, sorry, I did have one thing. I have a very good memo that was prepared by Becky Burr at the Wilmer Hale Law Firm talking about some of these issues, and I would like to, with your permission, enter this into the record of the hearing as well.
If you'll give it to us without objection, it will certainly be entered into the record, and I thank you. And with that, I thank the witnesses, and the hearing is adjourned.